Hello, my name is David Eddy, and I'm the co-chair of the Antitrust team at Nexsen Pruet, where I've been practicing for 21 years. Our team offers a full-service antitrust practice, and we have been representing companies that have been injured by anti-competitive conduct for almost 20 years. Anti-competitive conduct, or violations of the federal antitrust laws, can take a variety of forms that are often very difficult to uncover, such as agreements among competitors to fix or stabilize the prices of products, to rig bids, to allocate markets or customers, or to reduce the supply of the product in the market. This conduct can be criminally prosecuted and can cause significant economic injury to buyers through higher prices. Companies are in many instances first alerted to a potential antitrust claim when they receive notice of a pending class action settlement. In that situation, the company faces a decision. Should it remain a passive member of the class action, or should it exclude itself or opt out of the class case and pursue its own remedies? The consequences of this decision can be significant and have to be made within hard and fast deadlines set by the court. For example, if the company elects not to opt out by the court-imposed deadline, it will remain in the settlement class and be bound by the terms of the settlement and the broad release of claims to the defendants that are given in those agreements. There are a number of factors that a company should consider when it believes it was overcharged by a price fixing, conspiracy, or other anti-competitive conduct. The principal benefit of remaining as a passive member in a class action will be that the company generally needs to do nothing in the case, and it will pay no out-of-pocket fees or costs. This can make sense for companies with small claims that do not merit individual attention. However, there are a number of significant downsides for a major buyer to remaining in a class action. The company is represented by class counsel that it did not select, does not know, and with whom it will never communicate during the case. As a result, the company will have absolutely no say or control over its claims and its potential recovery. When a company excludes itself or opts out of a class, it controls its case. It will hire counsel of its choosing, it will work with economic experts that will focus only on its claims and can settle its claims when and how it wants. Significantly, our experience in representing companies that opt out shows that they are able to secure a far better monetary recovery than if they had stayed in the class, generally by many multiple times better than a class member. Indeed, the federal antitrust laws are designed to encourage and incentivize individual lawsuits through mandating that damage awards are tripled, permitting the recovery of attorney's fees, and applying joint and several liability to all conspirators. Finally, another major reason for buyers to hire independent counsel is to ensure that their claims are preserved and advanced in a timely manner. The federal courts recently have imposed increasingly tough standards on the certification of class actions in antitrust cases and have found that many proposed classes fail to meet these standards. This is very important because if a class is not certified, affected companies may discover several years or many years down the road that no one is representing their interests or pursuing their claims. This recently happened in the rail freight fuel surcharge antitrust litigation, where after 11 years of litigation and appeals, a class action was not allowed. Major buyers were then forced to file individual suits 15 years after the events. In sum, we strongly believe that a company with a large potential antitrust claim is best served by quickly retaining independent antitrust counsel to evaluate its claims and pursue, if merited, an opt-out strategy. While the major focus of our antitrust team is helping companies recover for injuries caused by antitrust law violations, we also provide a full-service antitrust practice for our clients, including class action and individual corporate defense and prosecution among all areas of antitrust law, advising clients regarding government investigations, business transaction counseling, and providing compliance policies and training. If your business needs assistance with any of these matters, please reach out to us today. We stand ready to serve you.